Alrighty, people. I think we are live. I don't yet hear myself echoing in the background, so it looked preemptive F. Can everyone hear me well? And yes, I think we can. Okay, let's get the Fs in the house. You know what? I think we've discovered what the intro theme is. R&R has Faith. Good evening, Faith. What does Salty Cracker have? Well, he has the re. And Scott Adams has the communal sip from the coffee. Yeah, I get the gag F that I think everyone is serious about. And then I have a mild internal panic attack until I realize, there you go. Look at that. There you go. All right. We've done it, people. And now no one is ever going to know how to bring out a bona fide, genuine F when it is needed. Like the time, when did it happen? Whatever. All right. So how is everybody doing? I just got the notification that we're live. That's a good sign. But that's from my own personal account. Audio looks good. Man, what is going on in the world? It really looks like it's a crazy world out there. I mean, yeah, I do wonder if it's social media trauma, if it's, at this point, it's not. I know that it's not. Social media is not amplifying and exaggerating problems that are not real and serious and prevalent out there. The world has gone mad, like certifiably mad. And up is down, down is up, and nobody seems to want to, mention that the emperor has no clothes. Okay, so where do we start? Do we start with a little opening rant? It may not be much of a rant. We're going to talk about it tonight. I went down to the protest. That word seems to get videos temporarily demonetized. I went down to the gathering, the manifestation, as we say in French, manifestation, yesterday to see what was going on. Sorry, who need a way to enforce governance to end the lockdowns, period. Yeah. I went down to the manifestation to see what it was like to get a feel for the lay of the land in Montreal. And it was one that was organized by parents, in opposition to kids being required to wear face masks. So it was relatively tame. I think the police were probably not coming out with full tear gas, given that there were a lot of kids there. Crazy times in Canada. Doesn't look like it's getting any better. So I went down. I wanted to see what the policing situation looked like, what the general sentiment looked like, what the turnout would be like, and it was what it was. It was not extreme yesterday, at least. Police were out there giving tickets left, right, and center. $1,500 tickets. Viva, how are judges chosen in Canada? By appointment or election? It's by appointment. We don't have elected judges that I know of in Canada. And if it's an election, are you warming it to an idea of running yourself? I'm the announcement. I don't know that there's an announcement. I'm looking, before I run from the country, I'm going to run for office. So I may have to get the dog, or we may have to just let the dog bark. I say, before I run from the country, I'm going to run for office. So we'll see what happens. Because it can't keep going like this without it leading to, I don't want to say doom and gloom. I'm not trying to be despair. One second. Yeah, we're not going to be able to deal with that for too long. Winston, why are you making noise? He doesn't know. A society can only put up with so much before those with the means leave, and the society just implodes on itself. The police yesterday were giving out $1,500 tickets like it was cotton candy, like it was candy at Halloween, whatever, you know what I mean? Just, here, $1,500 tickets. Now, there is a big argument as to whether or not they're ever enforceable if you contest them and go to court, whether or not the courts are going to enforce them. But they're just handing them out, and people are distraught after having gotten these tickets. Some people, $1,500 is more than a mortgage for a lot of people. It's more than a month's rent for a lot of people, and it's capricious is not the word. It's arbitrary. It's just pick someone. You come here, and it's either ask you to put on a mask or give you a ticket for not having a mask. And $1,500. Just out of your pocket, just stolen. Like now the police have turned into the tax collectors for the government so they can subsidize the fact that they have hundreds of police at a protest, more than hundreds, or hundreds of police at a park, literally policing a park on a sunny Sunday afternoon to ensure that everybody in broad daylight, open sunlight, is social distancing. And if they're not, $1,500, poof, like magic. Let me just get some super chats here. And today I went down to the Tam Tams, which is I think it might be called Parc Jean Mance also, the Tam Tams. It's where the drummers are. And I was down there and I put out a video on my second channel, not to plug it, Viva Family. It was an apolitical video. It's just, Sunday in Montreal during COVID. The Tam Tams, which ordinarily have thousands of people doing things that are legal now, actually. So nothing wrong with that. Nothing wrong with it because it's legal, but whatever, YouTube, okay. Thousands of people dancing, drumming. It's people selling stuff. Today I went down, maybe hundreds of people were there, and there were what looked to be at least as many policemen as people, police men and women as people, issuing tickets. I saw two women getting a ticket. I only saw it from a distance. I recorded a bit of it. They looked distraught. $1,500 for people who are out of work now. And for people who, even if you're not out of work, $1,500 is a month mortgage for people. It's a mortgage. It's an economically crushing fine. And so I went up to one of the cops and just asked, how do you feel about what you're doing? And this individual said no comment. And it was a wink, wink. It was an honest no comment. I know what he meant. And then I said, internally, are police not talking about, taking a stand to not enforce these arbitrary measures because they change willy-nilly from one day to the next? And no comment. But then, let's just see this. Dr. Baker, okay, we're going to get here, Tara. And then, if anyone's on Twitter, Ian Miles Chong, I don't know how I ended up following him, posted a video from Jean Mance Park of 6 to 8 officers brutally assaulting an individual, choking him out until he's unconscious, then hitting him on the head when he becomes conscious again. Nobody knows why. A lot of the tweets are immediately jumping to race, which I don't immediately jump to race. The individual did appear to be dark-skinned, if not black. I don't jump to race. I was down there today. I know what the cops that I saw out there were doing and what they were out there to do. They're all, they're on bikes, they're on foot. They had the green pennies. They were out there to give tickets to people who were not wearing masks. And that is what I suspect instigated this incident. Although I don't know any better. I just saw the videos on Twitter. But this is how you break people. This is how you break a society. And I've made my joke now. We've got 52 minutes left of outdoor time because Premier François Legault, the sunset thief, as I'm calling him from now on, has backed the curfew to 8 o'clock. The 4-week curfew, which started in January, graciously extended after the third week to 9:30. After the third week of the 4-week curfew, is now being brought back to 8 o'clock in the freaking spring summertime. People are locked in their houses over winter in the best of circumstances just because of the weather. And now he's bringing it back to 8 o'clock because science, I've said it a dozen times, his own medical expert, Horatio Arruda, said there's no scientific evidence to show the effectiveness of a curfew. And then you got the propagandists on CJAD radio saying, I saw somebody going into someone else's apartment at 5:30, and they're just going to stay past 8 o'clock unless you bring back this curfew, to remind people of how serious it is. This is the loser think, is we already have laws that people aren't following, so let's make more laws to punish the people who are not following the laws in the first place, when the only people you're going to be punishing were the ones following the laws in the first place. Hey, when the existing laws don't work, more laws. Rustus and Royd with a cat with cucumbers on its eyes and a thing. Very cute. We need people like you. I hope you do run for office. I got to run before I run, but I would be lying if I said, this is how you push people away from their home. Because you're walking outside and seeing police patrolling a park. Oh, what instigated all this is that I saw a video on Twitter of the police going through another park, Jean Drapeau, I think it was another park. It was another big park. A police van driving through a park, blaring on its speaker, You must all remain 2 meters away from each other, failing which you will get a fine between $1,000 and $6,000. $1,000 and $6,000. They do it in English. They do it in French. I swear to you, it was straight out of Total Recall. It was something you would expect to see in a science fiction movie of how society has gone mad. And it's not in a movie. It's not a joke. It is happening today in my own bloody city, my own country, courtesy of the sunset thief, François Legault, who now is locking people in their homes at night at 8 o'clock when what they need is not to be locked down. What they need is to get exercise and be healthy psychologically and physically. But no. And while he's doing this, by the way, I screenshotted it and tweeted it today, running ads on the internet. Don't worry. Hey, if you're locked down, go gamble at the casino. Take your $2,000 CERB money that we're giving you because we put you out of work and go gamble it away at the casino. Take your tax dollars one way, and if you don't get you to the casino and you actually dare go outside, $1,500. We'll take your month away from by giving you a ticket. Sweet, but goodness. Okay, now I've missed a ton of super chats, which is going to bring me to the comment. Let me just see how many I can get before we go lose them all. Okay, sorry, I didn't mean to bring that. Oh, that's losing my mind here a little bit. It makes it difficult to smile, and I'll tell you that. Viva, I hope I'm not watching the sane man losing his mind. Be strong, as I know you are. You are a voice of reason. Sorry. In a world of madness. Okay. Truth in a world of lies. Thank you for everything. It is it's very upsetting. Like, it's actually very upsetting. Could Barnes comment on Linwood's latest craziness? Whether Wood is still involved with the Rittenhouse case or not? Yes, we will get there. We'll touch on it. He may or may not be able to disclose certain. I don't even know what it is because I don't know what the latest craziness is. But he may not be able to because he's now involved in the file. So he knows his limits. Just as the Civil War started, local South Carolina said that the SC was too small to be a country and too large to be insane. I think the whole world is. Thank you. Yeah, public health. I am reluctant to venture off into beyond my expertise, but you can go to the government pages and see what the stats are. Okay, so all that to say, now I've missed a ton of super chats, and that's the intro warning. I'm going to miss super chats. If it's going to miss you if I do, please don't give it because I don't like people feeling rooked. YouTube takes 30% of the super chats. You can support us if you want to on Locals, vivabarneslaw.locals.com, where I've been putting up exclusive stuff there too. Not as much as Robert. No legal advice. What else? Don't spam. I put on 20-second slow-mo just, to keep track of the chat. Don't spam. It's the only thing I really hate. That and no overt threats, please, because that's my limit also. I'm a free speecher, but not for doing things. Anybody who does it on this channel, I think, is doing it specifically to try to get me in trouble, which is discourteous to the channel. You know what I think about everything in terms of the way to protest and the way to do it properly. And if you disagree, you're free to disagree. Don't sabotage my message, please. Okay, and then we go, if variance uses a pretext to continue restrictions, it will never end. Okay, I see Robert there. Robert, I think, has been smiling while I'm losing my mind slowly, but I'm not losing my mind. I want everyone to appreciate that. The risk online is when you say, when you express that you're upset, everyone assumes it's 20 times worse than it is. I'm upset. I'm frustrated. This is never the world I ever thought I would have lived in. And knowing the numbers and knowing the stats, it's not something I think is remotely justifiable. That's my opinion. And if I were to ever run for office, that's what I would run on. And I would bring back the fundamental value. You have to decondition a nation from the trauma that the government has imposed and inflicted on them for the last year. That's going to take work. Okay, I see Robert's in here. Let's do this. Robert, how you doing?
Good. It's my birthday.
I know, for goodness sake, you beat me to it. Robert, can I say how old you are?
Yeah, 47.
47 years old.
Yeah, 47.
47 years young, at least. And you're celebrating. It is Robert's birthday today, people. So this is not like tomorrow or yesterday. Happy birthday, Robert.
If you want to give a thanks to everybody who's giving the greetings, and if you're thinking about a gift, give the gift that gives back. Join vivabarneslaw.locals.com.
Robert has turned into the what is the word? Not adamant professional, but the perfect professional when it comes to locals. And it's an interesting thing. I know what Robert is doing. Robert is giving a lesson for everyone else who's on locals, how to do it and how to do it properly. And I am slow to learn the lesson, Robert, but I'm learning it. I'm learning it slowly.
Yeah, we got to take down big tech one step at a time. In fact, I'll have a deep state episode, which will be about the color revolutions this week. But there's instruction in there that's actually, the CIA has distributed it, but it actually comes from an original thinker about how to have nonviolent revolutions politically. And it might have particular application in our current environment.
Well, we're going to get to it because we'll talk about the incident, which I'm sure you've seen now, of Rebel News yesterday at the protest. We'll talk about it because there's a legal angle to it as well. But we'll get to it in due course. We're gonna go. I wanted to get the menu, but yes, it's nonviolent revolution, which is you can't win certain revolutions with violence because it only leads to exactly what was displayed yesterday at the protest. It only leads to that, and it's. Yep. People will call me all sorts of names. I screenshotted our menu for tonight. Ugh, I lost it. Hold on, Robert. I'll get what's on the menu anyhow. But that's it. So that's it. Okay, look, let's get started. We're into it. 15 minutes in. It's a good time to start. We're going to go with Chauvin. Maybe we won't spend quite as much time on it as we did last week, but there are some things we need to go over in terms of evidence and some questions we need to clarify for the people out there. We're going to get into Clarence Thomas. Another very insightful concurring judgment, which seems to be ringing the bell loud for how to fight the problems that we see. What else did we got? We got Joe Biden on the Second Amendment
and the Fourth.
Geez, okay. You know what? While we go over the first, I'm going to get to the list. And what was the other ones? Geez. We'll get to it. Oh
yeah. There's plenty of items to cover. Rappaport getting slapped around by Portnoy and Barstool Sports because apparently even being said that we'll get to it.
Okay, let's start with Chauvin and we'll get into this stuff afterwards. Okay, so the Chauvin trial is finished now. Week 3. It's week 3 where it was the prosecution's expert witnesses. So they had expert.
I guess it was the end of week 2 from a trial perspective. They've had 3 other weeks of jury selection.
Okay, so the jury selection where they took care of some evidentiary issues. The big news of this week were the prosecution's experts.
Yes. So week 1 was a motion from the prosecution, and week 2 was authority. And so I always recommend that book, Reptile, that they write about how the reptile brain influences and shapes people's decision-making. It was written for, one of them was a plaintiff's lawyer, written for them, sort of like the behavior panel of emotive analysis for how logic works, in terms of how jury decisions really work, that the unconscious part of our brain dictates our decisions, and we use the conscious part of our brain to rationalize those decisions. And I think the prosecution has done a much better job than the defense at going to those aspects. And that continues. The week 1 was all about emotion from the prosecution. Defense was about logic and fact and law. And I think that's the myth of how our legal system operates. It's very rare that a jury actually functions that way. And week 2, to me, was really, again, more about authority than it was about evidence. Because on some of the evidentiary grounds, they conflicted with each other. They were weak. There were a lot of problems.
So, and that's the biggest thing I think people need to appreciate for the week of expert witnesses. They had 4 expert witnesses, one of which was the actual expert who performed the autopsy. And so
4 medical experts, and I think it was 4 use of force experts.
Okay, sorry. So I'm in the medical side right now, because the issue that occurred on the medical expert side was that 3 of the experts had determined one cause of death, which was asphyxia due to a neck constraint, and the autopsy, Dr. Baker, who performed the autopsy,
actual medical examiner,
he did not, from the questions that Nelson had asked, did not seem to have indicated that cause of death in the actual coroner's report. So
no, exactly. And I mean, it's always a problem for a prosecution when you can't use the state's own medical examiner who conducted the autopsy, who's the real expert in that area, to be the lead expert for you. Instead, they brought in 3 other experts. And one of the problems that we talked about before the trial even started was the concern that the medical professional class, as a class, the people who are experts, would, for political reasons, be motivated to be on the state side and not on Chauvin's side. And that became clear early on because several of the state's experts didn't take any money. And to me, that's a bad sign if I was a juror. Now, I don't think these jurors interpret it that way necessarily, but because my question is, okay, hold on a second. You're not getting paid for your opinion. You volunteered, and you volunteered for one particular side before you even saw the evidence. So that tells me that you were really oriented towards a preordained conclusion. If people think that getting paid causes a problem, for the most part, it does not. Jurors know that, and this comes with it. To me, it's a bigger problem when you volunteer for free in your first ever criminal case, as one of the lead witnesses, Tobin, was. And that tells me, okay, you went in looking for an excuse to blame Chauvin for what took place. That means you're even more biased than a regular one. And then he proved that later on in some other proceedings. But I look at this in two different ways. One is how most jurors react. Most jurors react in what the prosecution was really doing, in my view, was authority. They're saying, look at this person's written a big book. Here's the police chief. They brought in the police chief. Look at these trainers. Look at this big LA use of force expert. Look at this big doctor, this big doctor, this big doctor. And that's really what the argument is. It's along what Reptile talks about. It's emotion first, authority second. Emotion says you got to do something here, and then authority says this is who you have to do it to. And I think that matters often more than the content or substance. But let's say it's a jury that's one of those rare 10 or 20% of juries that's really was open-minded and is really trying to dig through the facts and come to a conclusion. In that aspect, I think it was not such a great week for the prosecution. Started off terrible. Their own use of force experts undermined their position repeatedly, especially the ones that came from Minnesota. And then despite their authoritative declarative statements, which were too strong and too certain and direct. And then on the medical expert side, though the main expert, they're contradicting each other, as you point out. The medical
just so no one accuses you of misstating it or overstating it, three agreed, but not with the one who actually performed the autopsy, the dissection, the analysis of the body. So
yes, exactly. And basically they went out and found some experts. In this case, they volunteered, most of them, to say what they wanted to say because the state's own medical examiner didn't say it. And that's a problem out of the gate. As a prosecution, you never want to. I've almost never seen a case where their own medical examiners contradicting their lead expert. That's just, especially when their lead expert is so certain, that creates a problem. I mean, and again, the state had to put up the medical examiner because they knew the defense would make them look worse. So the jury hears them. I would have waited to put up the medical examiner next week and concluded on the same message. Instead, they concluded on a message that rebutted their original message. And that original message didn't come with any hedges to it. And so the medical examiner's conclusion was that basically stress, it's what we talked about beforehand, that stress is what killed Floyd in part. Now, one thing that's critical here is they do not have to prove that the sole or but-for cause of death was Chauvin. They just have to prove that Chauvin contributed to it.
And this is one of the points of clarification that we need to go over this week. The prosecution does not need to prove that he was the sole cause or even the primary cause, but a contributing cause.
That's exactly right.
And if they do succeed in proving that Floyd had heart condition, he had drugs in his system, he had COVID, he had a cardiovascular disease, even notwithstanding all of that, and in fact, notwithstanding, like Requeda said, notwithstanding of whether or not he might have very well died within a half an hour, if Chauvin can be proven beyond a reasonable doubt to have been a contributing cause to a reduction in what would have otherwise been remaining of George Floyd's life, then they succeed in proving the assault.
They don't even have to prove that. They just have to prove he contributed to his death. It doesn't matter if he changed the time frame. All they have to do is it's a substantial factor. Now, it can't be a minor factor. It has to be a substantial factor, but that's it. So that's why causation is not that. That's why I thought they made a mistake. The problem with getting these true believers as your experts is that they want to be very certain in areas that are inherently suspect of certainty. And in a case like this, and similarly, I mean, Dershowitz made the same comment. He said he believed the expert up until the expert started making very declaratory certain statements. Then he was like, okay, this guy's clearly got a bias. But the other problem is that they're trying to prove something. One of our lessons or mantras: don't try to prove what you don't have to prove. But that's what they've set out to do. At least the experts did, by saying no, it can only be this. And frankly, that's when I thought the prosecutor's lead expert, Tobin, did his most damage to himself, by saying, when you start saying smoking doesn't hurt you and heart disease couldn't have caused anything or contributed to it even, and and that, I mean, I think something like 90% of smokers, he said, don't suffer any problem from smoking. At least that's how it came across. A lot of people were like, and this was where I made a point on social media, which was that if I was the prosecution on the expert, I wouldn't have them go up and say he's breathing totally fine and he died from inability to breathe. I understand that they have an explanation for that. My point is that, you remember, this is a jury that's no way going to get self-educated or trained in this area of medicine. That ain't happening. So their ability to understand is going to be pretty basic. And like I said, most of the argument's really from a position of authority. I'm a position of authority. I say guilty, end of story. But in terms of it, if you're worried about a jury that's actually focused on evidence, I would not make arguments that contradict common sense and or that sound like they do. And he did that, I thought, repeatedly. And he didn't need to from an evidentiary perspective. They don't have to prove that heart disease wasn't a factor. They don't have to prove that. They just have to prove that that it was a substantial factor, the nature of the neck and body restraint.
And if they prove a substantial factor, they get to assault and then they get to felony murder because, in theory, according to Minnesota law, they have proved the underlying felony causing death. Hence, they succeed on the claim. So I'm just going to bring up
proven intent, obviously, but that just shifts the issue to intent and use of force, and removes the causation question. Those are the two big issues in the trial. What was Chauvin's intent? Was it did he know he was using force so excessively that he was likely to cause substantially bodily harm, or knew he was likely to cause death in the cases of the top two counts? And then did he actually cause the death? The other problem with his testimony is something that we predicted before the trial even started. That I said that if they're going to blame the restraint, then my view is that he likely died at the 4 or 5 or 6 minute mark, and that most of the length of time he was on someone who was dead. Well, Tobin basically said that. Now, I don't know if they've thought it through. This is what happens when you have a gung-ho expert who only has a slice of the case, eager to prove his slice of the case. Is that means that, like most of the complaints are, why didn't he turn him over once he wasn't moving? Why didn't they provide CPR? Why didn't they provide help when they knew that there was no pulse purportedly? Well, all that happens after Tobin says he was dead. So that can't be a legal factor now under Tobin's own theory. Under Tobin's own theory, it's only what happened while he was still doing things that were physically consistent with resistance. They didn't make sure Tobin's testimony lined up with their use of force testimony. It appears they actually ambushed the defense lawyer and came up with with this breathing explanation in part to refute the fentanyl the night before.
And it's something I brought up a chat which said, how is Chauvin supposed to know of Floyd's heart condition? So that is the eggshell theory, Robert. I'm not mistaken on this. Is you take your victim in the state that they come, whether or not you know that they have an eggshell for a skull and it's an actual.
You still have to have the intent that what you're doing can cause serious bodily harm under the manslaughter count, and you still have to establish intent that he thought he was going to kill him in the top two counts. So his subjective state of mind still matters. It just matters to the intent side, not the causation side. And so it's two different levels of analysis. And that's where I thought it was, they should have, try to rein him in. The other problem was a lot of his testimony was highly speculative, and credit here to the members of the VivaBarnesLaw.locals.com board. A bunch of them have medical experience or family members that do. And they responded because one of the things he said towards the end, because the biggest thing I was curious was not blaming the restraint. I knew that, okay, sure, they're going to find somebody to blame that, but exclude the possibility that fentanyl was the sole cause. Explain why that was. And I thought they would just say it was a cause, but not, I didn't know he'd go as far as this guy did. But one of the statements he made that I thought, I'm pretty sure that statement's false. Not being a medical expert, but having read some of the medical literature on this and talking to people who are medical experts. He said it couldn't be fentanyl because you have to go into a coma before fentanyl. Now, I think the prosecution was actually being sneaky. Throughout the case, they've often framed the question that if you read the question, the answer is honest, but the answer doesn't mean what it sounds like it means because the question's actually more hedged. So I think they were saying a traditional fentanyl overdose, which usually goes into coma and then death. But my understanding is one of the defense's theories is that this was caused by what they call wooden lung, where the muscles around your lung don't work because of fentanyl, and it basically prevents you from being able to get the oxygen you need to breathe. I thought he would get into why excluding that possibility on direct. He did not. It came up only on cross. And I think the defense lawyer was thrown off, so his cross was not one of his more effective cross examinations. But his explanation on redirect was no. If it's fentanyl, then the only way you die from, or the way it was interpreted, is if you go into a coma first. And I was like, not in wood and lung situations, because everything I read says rapid death, rapid death. The members of our board came in and confirmed that. And they said they went through and said there were a bunch of problems with his testimony. And the problem is he's a lung expert. His book is on mechanical ventilation of lungs. He's not a forensic expert. This is his first ever criminal trial. As the other experts end up admitting under cross-examination, if you just look at the medical evidence, just look at the autopsy, then your conclusion would be heart disease or OD. They only were able to conclude something different because of the videotape.
Now, that was the woman, I forget her name, but she basically said, looking only at the report itself, not knowing any external factors, not knowing the context of the video, you would have come to the conclusion it was an OD or heart condition.
And what that tells you is that they're not really giving medical testimony. They're giving forensic expert testimony. And they're not forensic experts other than the medical examiner.
But it was also their explanation. I thought, it was strong, and it appeared strong until, it comes in with Dr. Baker, where they say it would have been, we would have classified it as overdose or heart conditions. But, we saw the video. So now we're going to change our opinions or modify our opinions a little bit, except Baker comes in and says, Nelson asked him in cross, if it were caused by pressure to the neck or pressure to the back, would you not expect to see bruising or some sort of trauma on the body? And did you? And the answer was, I think his answer was, I would expect to, and I didn't.
Right. That's why he, right out of the gate, he didn't say there was asphyxia. And this was the backstory. What happened was, the reason why the county prosecutors cannot be involved in this case is when he gave his initial notes. He even put down, if you just brought him in without you telling me the background, I would conclude this was an OD. They, helped, put it this way. After he met with them, his opinion clarified to blame the stress from the event. Now, there's a lot of problems with that. Intentionally inflicting stress, is that a crime? Because, by that definition, just handicapping him may have been enough stress.
Everyone has to appreciate that this is also within the context of an arrest of an individual who's resisting arrest. Yeah. Whereas if it were a civilian and this was just people doing this who don't have the authorization to use force, it would be a totally different debate. I'm going to cough here. Hold on a second. And no, it's not anything. I just inhaled some water. So the question is, what I found particularly egregious, and I don't remember what day this was now, is the training expert was asked, do you recognize this method of restraint? And she says, no, don't recognize it, except it's in the manual. So if they're not allowed using what's in the manual, how can they ever put someone under arrest? Now I'm going to cough for another 30 seconds. Hold on. Take it away, Robert, and cover for me.
Yeah, no problem. So, on the use of force side, they got taken apart because they made declaratory statements that were just false. They tried to use only one photo image. When you look at all the photo imagery, it's clear that often his knee was on his back, not his neck. But the biggest problem from day one on causation, and to some degree intent, was that normally, and the medical examiner sees this all the time when he evaluates it, is two major facts. Fact one, there was none of the signs of damage to the ribs, to the rib cage. One of our locals board members pointed this out, whose wife was a doctor, was like, there's huge problems with with Tobin's testimony. But is that there was no physical signs at all that he was having any, there was no external signs that his body had been put under such pressure that he could not breathe. There was not even bruising, basic bruising on the shoulder didn't exist. And that was always problem one. That was the medical examiner's problem with saying asphyxia was the causation. The second one is, they decided to play the data game, which I think is going to backfire on them. They decided to compare they're like, hey, we've pulled people over under DUI who had a higher level of fentanyl intoxication than Floyd did. And then they also brought in data that showed about 600 people who'd been arrested and still alive with that level of fentanyl. They also showed about 10,000 people who had died with that level of fentanyl. They had some explanation for how one was different than the other. And I get it. Again, it's about the prosecution's done much better than the defense on this. Visuals, charts, authority. It often doesn't matter what they're saying. Just look at our current lockdown situation and see how often actual data is irrelevant to policy. It's just put up a pretty chart. Scary. Got to do all this stuff. And it's similar because it works. Reptile brain, folks. But if they really are digging into the evidence, the problem is going to be going back to the second reason why that medical examiner was reluctant to attribute it to it. He himself said he'd never seen a death caused by being on the back of the neck with no physical injury to the neck that was asphyxia. And that's because there are plenty of studies on this. Thousands. Actually, they did one in Canada, and they found like 3,000 plus people that were put under severe physical restraint and a lot of bodily force put on a person. They found 0 deaths. As I've mentioned, several hundred of them in Minneapolis in the 5 years prior to this, no deaths. As a Minneapolis professor, did a big study looking at whether that body weight 3 times what they're saying Chauvin did not cause any physical serious bodily harm. So that's the problem that they have, and they're just pretending that doesn't exist. And so we'll see how it works. I mean, I still think that I thought from an evidentiary perspective, Tobin was an effective expert from a public persuasion perspective. How effective he was with the jury, I'm more skeptical about that because, again, I think he's there for authority, not there for the substantive qualities of his testimony. And, I mean, I've had trials where my experts were 10 times better than the other side. Didn't matter. Pedigree was 10 times better. Didn't matter. And I've been on the opposite side where I didn't have anywhere near the experts and won because that's not quite how the jury's mind tends to operate that much beyond authority. Defense will have its own experts to say something different. Well, so I was highlighting, if you're looking at that 10 or 20% jury chance that they're really digging into the evidence, on that side, the defense kept winning. They didn't make as many points with Tobin as they could, but they set him up for closing argument is what they did.
Now, speaking of which, I want to get back to Cleopatra's. First of all, Linda, thank you very much for the super chat. And Cleopatra, welcome back. Happy birthday, Robert. Gentlemen, how much longer is the trial expected to go on? As soon as I heard the tape, I heard the tape where he said, I can't say it for YouTube reasons, I think. I agree with those who are saying he killed himself. So
it's fascinating. It's a classic verbal what you hear one because it's either I ate or I ain't got or I ain't something like that.
It's the Laurel Yanny thing.
That's it. Yeah.
But the interesting thing is a lot of people are asking, first of all, why wasn't there an objection? Because that was leading the witness or that was a suggestive question, but it's in cross-examination.
Yeah, you can't lead it. Which was brilliant, by the way. It's called priming. Eric Hunley, Unstructured podcast. It's very well done. He mentioned this. This is classic priming. This is why I recommend people to the behavior panel and to Eric Hunley puts all those people on. Because it teaches you about how the human mind really operates, whether you're dealing with political persuasion, economic persuasion, legal persuasion. That was genius of him. That was genius the way he did that.
For anybody who didn't see it, he plays the video, asks the guy, what did he say? The guy says, I don't know. I forget who the witness was. Says, I don't know. And he says, does it sound to you like he said, I ate drugs? And then he plays it again. And the witness still says no. But the whole problem is everyone in the jury just heard that. And I tell you, I heard the audio.
Like, oh, yeah, that's exactly what that sounds like.
And even if someone is inclined to think they heard I ain't and not I ate, coupled with the evidence which Nelson was hammering, the semi-chewed pills with the saliva DNA in the back of the car, we say the damage is done once they heard the question. My only question was, could the prosecution in theory have objected? And if they could, would the objection have looked guiltier than just letting it slide?
No, I mean, it was brilliantly done. I mean, there's no objection. He's just asking, does it sound like this? I mean, there's no grounds to object. I mean, you can lead obviously on cross-examination, and the way he phrased it, what even a leading question technically? Yeah, because does it sound like this? That isn't necessarily yes or no. There's other ways you can answer that. But it was well done. It was that was and that was a PR win and probably stuck in the juror's mind. They probably regret their sequencing. They should have gone emotion, then medical, then use of force. Their use of force experts were weak. They stuck them in the middle. They got exploited. It was an area where Nelson was really well prepared, and they had them saying stuff that just clearly wasn't the case, or was an exaggeration. My view was they should have focused exclusively on I thought initially they should have focused solely on that he didn't flip him over when he's supposed to flip him over, because there's a lot of that's where Chauvin is weakest. Instead, they tried to say that even putting the knee on the neck was never okay. That's what one of them suggested.
Well,
Two of them suggested that.
No, I was having a discussion with other lawyers. I said that statement lacks credibility. Like, it lacks credibility because it's in the manual. So the question is not was the move approved. The question was the move approved for the duration of time for which it was used, given the circumstances when he became unresponsive, and then it's going to be a question of, was the situation a hostile situation enough that, he didn't feel that he could do anything but maintain the position, whatever.
And their medical expert blows it all up. Says, hey, don't worry about all that. He was already dead. He was already dead early on. He was already dead at the time all the most problematic use of force took place. I don't think they've thought that through entirely. And just like they hadn't thought through, like Robert Gruler made this point watching the Watchers on YouTube, also as a locals channel, watching the Watchers.locals.com.
And he's been doing some of the greatest coverage. I tweeted it out as a serious joke. I'm jogging on the treadmill, watching Robert Gruler's assessment so that I can start putting things together. It's great analysis at the end of every day.
He put up, and by the way, this is why crowdsourcing is useful. Just like our locals board came up with a lot of data and information, I'm probably going to crowdsource for the Rittenhouse case in part because you get tons of great feedback and information that you just can't come up with all on your own. And one of the things that he pointed out that then showed up in Nelson's cross-examination later in the day, because I think he pointed it out early in social media, so it got back to different people close to Nelson, was, well, why was he saying if his breathing problems only occurred because of the restraint and nothing to do with his heart, nothing to do with fentanyl, then why was he saying I can't breathe from the time 8 minutes before he was being put in the squad car?
And it's an interesting thing. So Robert Gruler pointed that out, said, I would have asked the same expert who said, this was all when the knee started issues. I would have asked him, why was he saying I can't breathe in the car before anything started?
But I can tell you why he didn't.
Okay.
Because when you have a really good expert like that, that's very persuasive on the stand, that you got ambushed with the night before with his key material change in his testimony, you're scared of where that answer could go. Maybe this guy's going to come up with some great answer and so you figure I'll just save it for one of the lesser expert witnesses and then have my people put it up and then make it in closing. That's likely why he did it. He was clearly thrown off by that expert. I mean, they did a good job. I mean, the way I always put trials, actually somebody else who was used to work with me in trials put it this way: there's always going to be blood on the floor in a trial. You just want more of theirs than yours. But anybody who goes in, I had a great Bobby Kennedy, former prosecutor, who said Frank Turkheimer taught evidence at Wisconsin. He said anybody who tells you they did a perfect trial from an evidentiary perspective is either an idiot or an ass or both. And I thought, that's insightful. It's like you're always going to make mistakes. Just try to minimize the number of them. Well, and that's so I think that's part of it. Prosecution did a very good job on that side of the aisle, but there were risks. The risks were he cut off part of their use of force case. One, he contradicted the medical examiner. Second, and third, he made some statements that I think they can have a lot of hay with. I mean, if it turns out there's a bunch of defense experts get up and say, "Oh, under Wood and Lung, everybody knows that you don't go into a coma, you just go rapid death," and they have several, and they cite a bunch of learned treatises and the rest on it, then he looks like a liar because of the way that he presented them. And all of a sudden, they've done in that 10 or 20% chance they're really following the evidence. I thought this week was a bad week for the prosecution. Even their top witness set themselves up in bad ways down the road.
And just on the issue of asking that expert the question himself, that was my impression as well. It's, the old cliche, don't ask a witness the question you don't know the answer to, because that expert, if he's a smart, I don't want to say conniving in a bad way, but if he's a smart expert who's well prepared, he'll have a good answer. Ask another expert who didn't offer that testimony, and at the very least, the most likely answer is going to be, I don't know, ask him. But at the very least, by asking the question yet again, you ask the question is, why was he complaining about breathing in the car when that expert said, the breathing issues would be only as a result of the pressure? The most probable answer is, I don't know, ask that witness, but you've already planted the seed again, like you did with the, what did you hear in the recording? And incidentally, I was thinking, had he asked the original expert probably would have said he was already in restraints. That's enough to cause the initial difficulty, which was compounded by the knee. So probably better not to ask the witness who will give you a smart answer. Ask the one who is more likely to not to give you the answer, which brings us to how good a lawyer is Nelson.
Robert, I think he's a classically trained lawyer. So I think he's strong where you're taught to be strong. You're taught to be a very good cross-examiner. You're taught to focus on the facts and the law. And he does that exceptionally well. I thought the only person who tripped him up was that one expert, the main medical expert, Chauvin, for the prosecution. No one else really has. And he stayed away from problematic witness, stayed away from problematic questions. Brilliant job in that aspect. I think where he's limited is that a lot of lawyers are taught the mythology of the law, which is it's about facts and evidence and law, when honestly it's not most of the time. Most jurors, reptile brain, it's about emotion, it's about authority, it's about visual. And there he's been very, very limited. So that's where, like, people are asking me what I thought. I thought if this jury was one of those 10 or 20% of jurors that's just following the evidence, then this is going to be an acquittal jury, at least on the top two counts. But my view is that's rare. Otherwise, I think it's still 50% chance or better of conviction across the board, and at least 75% chance on manslaughter. But that's because I think after jury selection and opening statement, your case is usually over one way or the other, and the prosecution won on those two sides.
Robert, you probably had a similar experience that I've had with lawyers, opposing counsel, and the general impression that they give off. I think Nelson he's doing a great job. Setting aside, it is absolute David versus Goliath, not from the merits of the case, just from the technicalities of the case.
And the power on each side, the resources.
One lawyer versus a team on the prosecution.
About a dozen lawyers, private lawyers, some of the best private lawyers in the country, the entire state, the entire city, the entire media. I mean, he's up again. He has a fair judge, which has given him an opening, and he's been an exceptionally gifted cross-examiner. And those two things have Chauvin in the game if he has a fair jury. Now, the other possibility is he knows a lot more about that jury than I do. And if it turns out he picked a very good jury and knows that they are a fact-driven jury, not a normal jury, then he's very much in the game.
What I love is Nelson. Nelson can play off his image. His image. He looks a bit goofy. He looks a bit.
His ties have like a nerd knot. They're like this. Yeah, they're like something out of the 1970s.
He looks like someone who you might underestimate, and he looks like someone who always is nice, which makes it much easier for him to get away.
Very good at couching his phrasing. Very good at not getting upset or agitated very often. Very good at framing, and the sequencing of his questions is just brilliant. They all in that capacity, he's been exceptional. One of the best cross examiners I've seen.
Yep. No, I say, like, it allows him to get away with things where you might look at him and underestimate him, and also looking at him like he's a nice puppy dog. He can ask questions of George Floyd's girlfriend, which other people might get resentment from other people. So I think I once was in a file with a lawyer. I think he knows who he is if he's still watching. An old guy, and he would always joke about being old and being forgetful, which, and the judges always laughed, but like, they're forgetful when you're not forgetting, but playing it off as, I forgot to tell you or give you that.
Nobody did that better than Jerry Spence's last famous trial. He kept forgetting things he wasn't supposed to say in the trial, and he kept forgetting questions he wasn't supposed to raise in the trial.
Yeah, like if someone believes you, they believe that you forgot. But if they don't believe you, like you're someone like me, no one would ever believe that I forgot something. They would just call me a liar to my face. So he's playing on his attributes, and he's playing. I think he's doing very well. But I just could not imagine what it's like to be in his shoes right now, 24/7, day in, day out. He's got to be on fire against a massive team. One thing that people are asking: the difference between a hung jury and an acquittal. And
big. A hung jury, they get to try him again.
So
now, a hung jury is a jury where they can't get 12 to agree. They declare a mistrial, and they get to try them all over again.
It takes only one for a hung jury.
Yeah. What happens is if they're hung, the judge keeps sending him back and sending him back and sending him back, puts massive pressure on that dissenting juror to concede. And it's only if they can't or won't that he declares a mistrial.
Okay, but then for an acquittal, does it require all 12?
Acquittals, yes, acquittal. No matter what, all 12. Acquittal requires all 12. Guilty requires all 12.
So the three options are acquittal, conviction, hung jury.
Yep. Or the way I would put it is acquittal, conviction, or mistrial.
Okay. I may have to change my prediction then. I I think I said I could see an acquittal on at the very least the two biggest charges, but I might have to change that.
Well,
And
when you have holdouts, I faced that in the Snipes case. 9 of the 12 jurors wanted not guilty across the board. 3 held out, and that's why they convicted him of those 3 little misdemeanors that they thought would have no consequence because of those holdouts. So you often see a compromise verdict when there's a holdout.
all right. And now the question was this. Chris Waynard says, Viva Barnes is the most important podcast on earth right now. Thank you very much. That wasn't my question. My question was, son of a beasting, I forgot. Oh, son of a gun. This was it. Sorry. Who chooses the jury foreman? Has a jury foreman been selected yet?
Nope, doesn't happen until they go back in to deliberate.
Okay.
At the end of the case. And then the jury picks the jury foreman. If the jury foreman is like juror number 2 who couldn't wait to be on social media, apparently some juror was being asked about, I think the prosecution is monitoring these jurors because they raised the question last week. And then this week they were saying they thought one of them was talking about a book deal. And it's like, I've never seen it at all, actually. It's very rare that anybody is following the jury during trial. Sometimes they follow them and say something after the trial, but very rare during the trial. That also tells me the prosecution is nervous about a couple of jurors. But if it's that juror number 2 who was all eager to be on the jury, and she's the foreperson, she'd be the kind of person who would love to be, then, Chauvin is done. If, on the other hand, it's an African-American male, then one of the particularly certain ones that I was following during the jury selection, then he's in the game. So who the jury foreman is, if they come back and ask questions, usually by then we know who the jury foreman is. That can often be indicative of where the jury is likely going to be heading.
Okay. And then the last question that I had on this subject was, people are getting confused between reasonable doubt and any doubt. And
well, yeah, kind of. I mean, I find that those arguments by prosecutors lame. So here's the jury instruction in Minnesota. If you have a reasonable doubt is any doubt based on reason or common sense. So the impermissible doubt is doubt that's not based on reason or based on facts that do not relate to the case. So, but I find, any possible doubt, that's what any possible doubt means. It means, metaphysical doubt, things like that, doubt based on things that don't relate to the case. But if you have, as a practical matter, if jurors think somebody's guilty, does anybody really think they say, well, I think he's guilty, but not beyond a reasonable doubt? You're not going to find many jurors who ever think that way. The reality is the real evidentiary standard is more likely than not, despite whatever the legal standard is. So reasonable doubt just allows jurors who feel that a person's not guilty to feel more comfortable arguing that point. That's all it really does. I've studied a lot of juries, mock juries, focus groups, you name it. And this has been convincingly proven to me repeatedly. Mm-hmm. But I always give the Alfred Hitchcock example. So I think it's either that or it's a Twilight Zone example. Somebody told me once, but I used it in the Snipes case. And after that, prosecutors tried to prohibit me from using it in future cases. They think that somehow is why. And a lot went into that. But before you point the finger of blame, make sure that the person is may be certain of your accusation, lest you put an innocent man in prison is the core of it. And that's all that really means. But the beyond reasonable doubt should matter. Practically speaking, it is very rare it actually matters in most jury decisions.
All right. And coming up for this week now, prosecution has finished its evidence, or do they still have witnesses left?
They still have witnesses left. And I'm assuming they'll have a few. I think they still have the toxicologist left and a few others, but it's about to shift to the defense. And I assume maybe they've wrapped up the use of force, but they're a little weak on that. So they might try to buttress that a little bit. And then it's going to shift to, and I don't know if they have any witnesses specific to Chauvin or that day. I don't know if they're going to use any testimony from the other cops or not that, was already recorded or not. So we'll see. But, and then it'll shift to the defense. I think most, I do not think Chauvin will testify. Too big a risk.
People are asking, how about the drug dealer? Does the defense call him up, even if all he's going to do is take the fifth? Oh,
yeah, absolutely. Okay. Because that's part of their argument. It'll be up to the judge whether to allow the jury to hear it. They hear him asserting the fifth. But, in my view, it's pertinent because it's a person's assertion of the fifth cannot be used against them as a defendant. It can be used against other people in a civil or criminal proceeding, depending on the circumstance. So so to me, it's relevant that and we predicted that last week. Said that if that what was likely going to come about, and I took some crap from it with some commenters and whatnot, that it was speculation and what have you. Well, it wasn't speculation for very long. The evidence came out that the drug dealer was getting rid of drugs, throwing them over the thing. That he actually gave. That appears that what he gave Floyd looked like an oxy. Looked like oxy. Actually had markings on it as oxy, and it wasn't oxy. It had a bunch of fentanyl and meth in it. And so that he was giving him. I think it's called a goofball, because I thought speedball was with cocaine and the goofball was with meth and fentanyl. But I'm not a drug expert by any stretch. There's a story about that, but that's for another day. That'll be a real hot topic, Robert. That's all I'm going to say. That's a long story. But so I think, given the nature of it, there is evidence that basically, and I think his defense lawyer even admitted it. Basically, he could have been charged with reckless murder. They've charged other drug dealers in Minnesota for doing exactly what he did with reckless murder. They deliberately withheld that evidence because it undermined their narrative. So it's going to be another factor. So you not only have causation questions, use of force questions, you now have whether somebody else other than Floyd is responsible for Floyd's death, other than Floyd or Chauvin or those other officers. The drug dealer who gave him something said, you need to help get rid of this. I'm sure that's what happened. That part I'm inferring based on the evidence, but given he was getting rid of other drugs, why do you have a drug that looks like oxy if you're not trying to mislead people into thinking it's oxy?
No, the idea is like the idea that the drug dealer either gave them to him, encouraged him to get rid of them by eating them, which might then explain what people heard in the recording. I mean, that when I say now that's a doubt to some extent as to causation, but all of that said, if they nonetheless prove that Chauvin nonetheless contributed, then they still get their conviction of assault for manslaughter.
Yes, except for how they've set up their own case. Okay. I mean, in other words, they're leading the jury to think it's got to be all or nothing by having that medical expert testify the way he did. So that's not what the jury instruction will be, is my understanding. But they've put themselves, whenever people do this and try to, the Enron case was lost the moment the moronic defense Petrocelli, that idiot defense lawyer, first ever criminal case, what a criminal case not to be in part of, told the jury, this is not a case of hear no evil, know no evil, see no evil at Enron. There was no evil at Enron. Well, that was never going to be believed. From that moment, he convicted his clients, even though his client most likely was not guilty of the crimes he was convicted of. But that too is another story.
All right. So that is good for upcoming week. We're going to see where it goes. There's how much time left in the trial schedule? 2 weeks?
2 weeks. 2 weeks. Okay.
So
and we may live stream the closing arguments and give our take on them.
That'll be very interesting.
Right from the courtroom. But that will probably be first week of May is the quickest, is my guess, that we'll get to closing arguments.
Okay. And incidentally, if we do that to avoid potential problems, maybe we only do that on Rumble. And I should plug this also. We're live streaming on Rumble as well. I brought up the chat just to let everyone know how many people are watching there. Okay, let's move on. And we're going to share a story that's going to lead into the SCOTUS decision on the in-person prayers in California. The story is yesterday's protest in Montreal. I go down. I've never been to one. I didn't go down as an active participant because I'm not yet an activist. Right now, I'm still an analyst and just an explorer. I just wanted to talk to people and get the feel for the people who are protesting and get the feel for the cops, which I got more of a feel for today. But, it was relatively passive. The people were there, firmly believed in why they were there. It's parents concerned for their kids. It's teachers concerned for the trauma that is being inflicted on the kids. The incident that became the news of the day was what happened to Rebel Media. Now, more laws, less justice, people, never forget it. I'm texting Ezra Levant because I've never met him in person. I went to the protest. That was another reason. I wanted to meet him. He was down in Montreal. I get a text from him that says, I'm not going to be there. The cops have descended on our Airbnb, which was a boat in the Old Port of Montreal, everybody. It's beautiful. They have these boats that are like apartment hotels type things. And they rented one as an Airbnb for their entire team to stay over the weekend. The tweet comes out in the morning that cops have raided it. They've sealed it off. It's a crime scene. They won't tell them why, and they won't tell them what's going on, yada, yada, yada. Now, I don't retweet and endorse and say what an outrage until I know the details, for good or for bad, because I don't think there's really many details that can justify what's going on, but maybe explain it, maybe. It turns out, apparently, the police were called because it was an illegal gathering, because there were there were 21 people on the boat or something. These are the allegations from what I understand, whereas it was the team of Rebel Media congregating, from what I understand, on this boat. So that's one issue, is you have the police descending as though there's nothing else going on in the city right now that could justify these resources. And this was one of the reasons why I went down, is just to get a feel for what the cops are like in all of this. Are they reluctant, begrudgingly following orders? People are not going to be happy with that either. Or are they gung-ho? We finally have the power now to go bust some doors down and harass a media that is unforgiving to us, partially because they don't get federal subsidies. But then what ended up happening during all of this escalation is, Robert, you saw the video of David Menzies, the guy losing it with the policewoman, and it led to him getting arrested. Now, people are going to get outraged because the situation should have never escalated to that point in the first place, but you have the police there, you know, swinging the iron fist, so to speak, and then you have these reporters who are making a scene, for right or for wrong, but, you know, they're making a scene because they want to make the scene. But you have David Menzies getting a little too close to the police officer, not wearing a mask, because that is material in this context, getting within inches of her face, and then she pushes him back in a manner that would be irritating to anybody, like, back up and I'm going to keep my hand there. And then another officer pushes him, and then he pushes the other officer back. Not a violent shove, just a shoulder shove, which is enough in most places to get you into deep doo-doo with the cops. And then they haul him off and arrest him. And I don't know what charges he's going to face, but I heard he was released. I mean, Robert, so from a criminal law perspective, from an assault perspective, I mean, the whole situation is a powder keg that's being set up. Some might say by design, others might say Milgram, the Stanford experiment. Everybody's playing their roles and playing them well. What's your take on the video, having watched it? And what's your take of our country seeing this from where you are?
Yeah, I mean, I think it's a little bit shocking to people that are in the States, because I mean, I think to a certain degree, just like our conversation with Count Dankula from last week, the sidebar, if people want to just sit around and laugh for 2 hours, listen to that guy talk. He is the funniest, one of the funniest human beings I have ever talked to.
Someone said it was one of our, I mean, thus far, one of our best. They had to go watch it a second time, specifically the part where he's in jail with criminals and murderers and robbers. And they say, "What are you in for?" And he says, I made a video with my pug. Like, actually, that was more Irish, but he's in there for making a video. That's the UK, and literally for making a video. However offensive you think the training was for a YouTube video, you got dozens of police descending on media on their Airbnb boat in the port, and the situation,
a protest about their lockdown rules in the first place. So, I mean, it's I think it's been a little bit unsettling in the U.S. how much Canada and the UK do not really have First Amendment protections. I think they're witnessing it, and they don't want it here. But we're facing the same thing. The good thing is that at least as it relates to the church, this Supreme Court, Barrett was the fifth vote, and she was the right vote on this one, in making clear that the church will be protected and religious gatherings will be protected. And the Ninth Circuit's continual effort to ignore the Supreme Court's prior decisions on exactly this subject in the state of California, they kept carving out one exception, then another exception, then another exception. And now the Supreme Court has twice said, no, what we said the first time we meant, that you can't have these discriminatory provisions against religious gatherings in any way, shape, or form under the lockdown guise. And that was a great ruling because we don't want the U.S. to look like Canada, where you have like churches that look like a prison zone.
And to talk about that, I mean, I haven't done a video on it because, first of all, the news is emerging. But yeah, the police barricade a church, put up metal fences around the church. They seize a church, and apparently, from a tweet from Rebel Media, they put porta potties on the front steps of the church, from what I understood. And then you have people tearing down the fences, and it's arguable as to who's tearing down the fences. But it's all the more madness. By the way, I think I forget the premier's name is Kenny, who 5 years ago tweeted about how China was, violating the sanctity of churches. And lo and behold, it's 5 years later, and we've turned into this. The case coming out of this particular SCOTUS case, I didn't read the underlying cases, but I read the decision. This was about banning in-house congregation, where the plaintiffs were not asking for special treatment. It's the same type of thing as the other one. They were just asking for the same treatment as other businesses that were allowed indoors. And apparently the Court of Appeal says, no, we think there's a greater risk of spread for indoor prayer than for Walmart shopping.
Yep, exactly. And luckily this Supreme Court now is 5-4, Roberts was again on the wrong side of the aisle. And every Democratic judge is showing that they're going to be completely Democratic partisans on this issue, unfortunately. But Barrett took the right decision, was the fifth vote. It was per curiam, so we don't know who wrote it, but it was critical as it cited Gorsuch a lot and cited Gorsuch's concurring opinions. Because when Gorsuch wasn't in the majority, this decision is in the majority, and it adopted Gorsuch's logic. And he's been the best intellectual critic of all of these. And you can see how it's translating, because a district court in Minnesota struck down some rules regulating, again, churches. It's still better in churches than it is in other contexts right now, because the Supreme Court cares a lot about protecting religious expression. It hasn't been so good yet as to everything else, but at least it's good on the church side of the aisle. But it's already translating, because that district court, like 3 circuit courts before it, are now saying that Jacobson is not the proper standard to interpret these rules. And that was a huge seminal break. And that's where Gorsuch has taken the lead. Gorsuch was one of the first people to be very critical of Jacobson, say it doesn't belong as the governing or guiding light. And it was initially every court was citing Jacobson. Now they're running away from Jacobson. And that's a very, very promising sign for U.S. jurisprudence.
What is the basis by which they're saying Jacobson is not good law, not to be followed?
They're saying Jacobson is a unique historical context, and since Jacobson, we've adopted a structured constitutional approach to all of these issues, and we should stick with it. We're not going to undo it in the name of Jacobson. And they're relegating Jacobson to the dustbin of history, to which it belongs, as the foundational case in the trilogy of infamy.
Now, is this going to have precedential value, or is this just what we call an obit, or something they say en passant that is not going to have precedential value?
Oh, it does. The 3 circuits have filed published opinions now, and the district court just recognized that fact, published opinion as well. So it shows that the federal courts now recognize they have to apply the same constitutional analysis as any other case. Just because it's a public health issue, all our Constitution doesn't go out the door. And so they're doing a good job. Emergency is still kind of a loophole lurking out there, but not public health. And that's a very, very, very promising sign.
All right, excellent. And now, why they said it in the decision, this is now the 5th time we've had to correct the Court of Appeals. Is that as much?
Ninth Circuit in particular.
So
it's because all of the prior religion cases, all but one, all come from the Ninth Circuit. One comes from the second. And what happens, the Ninth Circuit keeps trying to figure out, well, you said this, but really that only applies here. And then the Supreme Court reverses it. They're like, well, you said that and that, but this is kind of totally different. You know, when you're praying inside your home, that's totally different than praying inside a church. I mean, it was absurd, but it shows you how overtly hostile to religion a lot of our lower federal courts are. But the Supreme Court is the restraints on religion are not going to be tolerated by this U.S. Supreme Court. They're going to be good. Whether they're good everywhere else, still an open question, because they issued some favorable decisions for Google on trademark law, which might have been right, or not trademark, copyright law, but some people interpret it as deferential to big tech. But that might be a good transition to one justice who's saying it's time to take on big tech, and that would be Justice Thomas.
He's saying it again for the 2nd time, and it's a beautiful thing. This was the video I actually wanted to do today until I saw the police state that Canada was, and I wanted to go see how bad it was. So Clarence Thomas, in another concurring opinion, basically is again laying out the groundwork as to how to challenge Section 230 or the issues arising from it. So I got a lot of questions, because he laid 4 prongs of attack, so to speak, or 4 arguments: common carrier, utilities, Section 230. What was the 3rd one, Robert? And the 4th one?
Basically, if you have a common carrier, a public accommodation, a common carrier exception, a public accommodation exception. The 3rd aspect was government coercion. So he basically gave a shout out to Bobby Kennedy Jr.'s suit that's pending in the federal courts in California, which is based entirely on that the Facebook was coerced by the state to suppress his organization related to the lockdown issues. And then 4th, it's in a footnote, and not a lot of people are paying attention to it, but he cites Eugene Volokh, who we've done interviews with, who basically suggested that Section 230 is unconstitutional because of its preemption. Its scope of preemption violates First Amendment for a range of reasons in the preempting state law context. And he favorably cites that one, which is it's very interesting. It's going to send a lot of people pursuing that. So what he's saying is, look, that big tech is much more like, especially he notes, when a company, an idea that I and some other people have been pushing out there is focus on those aspects of big tech that are big, that have monopoly share. And he basically said when a company that has a disproportionate share of something that's of the public space at some level, historically, we've said they do not have a right to exclude. And that's cable companies, phone companies, railroads, transports, public accommodation.
Public accommodation is public accommodation. What's the difference, I should say, between public
accommodation is broad. That's how we enforce our civil rights rules. That's diners, restaurants, parks, you name it. So that's very expansive. So his point is that we often say that your First Amendment rights, when you're doing something that's in the public benefit to the public interest and you're owning some part of the public space, that there's limits, that does not include the right to exclude them. You don't get to exclude them from the train, from the bus, from the taxi, from being able to send a telegram, use the phone, send a fax, be able to get cable service. And that's the common carrier context. Or when you're a restaurant or a hotel, you don't get to exclude there either, because you're open to the public for accommodation purposes.
This is a jurisprudential distinction and not a legislative one.
But yes, in the sense that because what he's saying is pass laws that look like this, and at least I'll say they're constitutional. So pass a law saying you're regulating them as public accommodation, or you're regulating them as a common carrier. There's efforts in Florida and Texas to do precisely that. Or he said, by the way, if you want to bring suit, why don't you challenge Section 230 as either being beyond its original purpose? That was his prior concurrence. He said, really, Section 230 is being misinterpreted. But also you can say Section 230 doesn't apply because this was really government coercing the action. And he's basically sending a shot across the bow to Congress, saying if you guys keep intimidating big tech to censor, you're going to get big tech sued for being an agent of the state, which is good. And again, the guy that to start this all was Bobby Kennedy Jr. He was the one to pursue this first in a high-profile case that's ongoing. And now he's got a Supreme Court justice concurring opinion in his pocket. And then third, and Bobby Kennedy Jr. will be later appearing on Sidebar down the road. And this week will be Allison Morrow will be on Wednesday.
This is going to be a good one.
It'll be fun. Old conscientious reporter. She's not old, but in the old conscientious style, old school reporting style. She's definitely not old. I don't want her like military husband to be upset. That guy looks like a super SEAL. He looks like he's out of one of those movies. Like you wouldn't, you could just look at him and be like, yeah, I'll do whatever he says. But but also that they can pursue it on the grounds of Volok's exception. So I think it was a great roadmap, a second roadmap he's given for people to challenge big tech and for legislators to also challenge big tech, and hopefully some of them will take him up on it.
Now, any legislation that would regulate big tech, explain to a schnook like me how it works. It goes state level regulation, or would it be federal regulation?
I mean, you have state laws regulating public accommodation, federal laws too. So it could be state legislators or Congress.
It's interesting, actually. So you could have, in theory, whether or not you'd expect Congress to do it, given its political leanings, you could have certain states doing it, which would require big tech to be law-abiding if they want to conduct business in those states. Yep. Is the risk that a Facebook would do what it did to Australia and just say...
What he did is he gave a roadmap for Florida and Texas to defend their laws. And other states are looking at it too. Because he's saying, one, you have a right to do so as a state, as a public accommodation or common carrier. Secondly, if they claim Section 230 preempts, look to my prior interpretation of Section 230, but also look to this footnote that says Section 230 can't preempt state law without violating other First Amendment rights. I haven't read Volok's opinion on that. I was actually unaware of it until I saw it, but that was very, very interesting. So he's giving a roadmap to multiple people to take legal action. And that's, again, leave it to Justice Thomas to be the lead on this. It's not a coincidence that he's the one that's the most conscientious about these kind of issues.
Fantastic. And Bobby Kennedy, do we have any status update on that suit, or
It's motions to dismiss are pending, and I'm sure they're going to be sending this in as supplemental authority in their favor.
Phenomenal. So the public accommodations, common carrier, they're not legislative until they become legislative at some point, state or federal. State coercion. Is that
violating First Amendment in some capacity. I haven't read the interpretation of it, but that's what he basically says.
okay?
Says that Section 230 preemption shouldn't be applicable for constitutional reasons, and then government coercion. So if you've been subject to censorship by any big tech, and it came after any state level actor said something to encourage them to do so, you now have grounds to sue, at least according to Justice Thomas.
Interesting. And I just now noticed, I noticed we hit 10,000, 11,000 watching. Make sure to give it a thumbs up if you are so inclined. Thumbs down generates the same algorithmic action regardless, but thumbs up make me feel better. And drop a comment just to explode the comment section right now. The question, okay, so he's done it again. Oops, he did it again. Clarence Thomas. The question is going to be, what is going to be the case that's going to set this precedent? And what would that precedent look like? I mean, someone's going to allege political ideological discrimination by big tech, whether or not it's state coerced, whether or not it is discriminatory in the common carrier public accommodations. It's going to take a judgment to basically set the limits of what big tech can do under Section 230.
The censorship issue will be Bobby Kennedy's case. So Bobby Kennedy's case will pursue that one. And I think on whether state law can regulate, probably Florida, maybe Texas, where will be the test cases there. So that's where these cases will be soon in the court system because of legislation that's passed, at least in Florida, I think in Texas, and in some other states too. And so, yeah, we'll see this theory tested within a year.
I just brought this up. Can the Chief Justice be replaced or substituted for an existing justice?
No, only if the Chief Justice resigns can someone else become Chief Justice.
Okay, now I'm looking at the subject matter. Okay, I guess we have to go to Biden and the Second Amendment issue.
Yeah,
I'm not familiar with it as to any degree that allows me to even give the intro. Robert, explain what's going on. I brought up one chat about what Biden can now justify doing on the basis of calling something a crisis.
Not only that, he said this week that not all amendments are absolute. That's the point of an amendment, is to be absolute. So, so that's where people were making jokes. They're like, maybe we could get rid of, I know there's an amendment saying women can vote, but maybe it's time, they're not absolute. I mean, it's another Bidenism. This week he announced a bunch of new regulatory controls he wants, new gun controls he wants. The more problematic aspect wasn't those declarations. It's what he's arguing before the U.S. Supreme Court, which he is arguing the U.S. Supreme Court that you can go in and seize somebody's guns. You can also do any other kind of seizure without a warrant, as long as you're taking care of the community. And this was another one of those dumb exceptions that Supreme Court allowed in to the Fourth Amendment that said, well, if your community caretaking role, you're allowed to search it without a warrant. And I understand the public policy reasons for that. But again, we'll pass an amendment if that's really so compelling. Don't start carving out exceptions and footnoting the Fourth Amendment in ways that don't exist in the Fourth Amendment itself. Well, now we get more of the egregious, excessive versions of that. So, they go to some guy's house, and I think someone called, worried about his mental health. At some point, he's out of the house. They go into the house, search it, find some guns, and want to use that against him without a warrant, ever procuring.
Okay, so yeah, I was just going to ask, no warrant. I mean,
no warrant. And they're like, well, we were doing this for community caretaking. And what they want is they want to just gut the Fourth Amendment entirely. Say, we can go, and you can imagine what the public health loophole would look like in this context. This would allow some of the things we saw in Canada, like pulling people out of their house because they're not masked, or too many of them family members in the same room.
That's exactly it. You create a pretext. We don't need a warrant. It's an illegal gathering. Quarantine Act, Public Health Measures Act, whatever. Now we get to do it. No warrant, no legal system whatsoever, because it's a declared emergency or a health crisis, and that gives you the pretext to do whatever you want. And incidentally, going back to the rebel media thing, they ended up trying to go to court to get a warrant and couldn't get one after all of that. But if anybody thinks the government is not going to exploit, to be polite, abuse, to be honest, if anybody thinks the government's not going to abuse of pretexts to exercise and flex their power, we have a difference of assessment of reality, and I prefer mine. So,
community, if there's two massive Fourth Amendment cases pending before the U.S. Supreme Court, we talked about the other one, the hot pursuit excuse, which just gets wider and broader and wider and broader. And for those people out there that are, the pro-police that say, hey, they should have that, amend the Constitution because it ain't in there. So you want a hot pursuit exception? So publicly popular? Then amend it. The reality is all of them know it wouldn't pass because it's not that popular. And the same is true with this community caretaking exception to the Fourth Amendment. It was always going to be misused and abused. This case provides a more egregious example. It's awakening more people because it's being used in the Second Amendment gun context as well. And that's why there's gun rights organizations that have made amicus briefs in the case. But it's going to be important for the Fourth, to a lesser degree, the Second Amendment, because if you can go in and community, take care of the community, add red flag laws, add public health restrictions, they can just come in and search your house for any loose pretext. So somebody's worried about your mental health. We're seeing how broad that's being interpreted.
It's beyond what I understood red flag laws to be. It's just,
according to our health officials, racism is a public health crisis matter. So we need to see if you have the right beliefs. Go in and search your home to make sure that you couldn't cause harm based on wrong think.
Yeah, Stephen Cannon just brought it up. I mean, I heard it. I didn't hear the full context.
They were always going to go there. And then the next thing is the climate. We have a climate emergency. We have to use emergency powers for the climate, which is a good transition into our next case. In New York, they've been suing all across the country on the grounds that the climate crisis, the apocalyptic version of the climate crisis, the Greta Thunberg version of it, one of our locals people did have a great Greta Thunberg sticker for a meme. They put it in the meme, but it'd be a fun little sticker, which basically you open up your gas tank and it has little Greta Thunberg saying, "How dare you? How dare you?" Which is just great. But but basically they've decided to try to use the courts to impose public policy where they couldn't win with state legislatures or Congress, using public nuisance laws to sue anybody they want to call a polluter. And New York City brought one of the first actions, went up to the Second Circuit. The Second Circuit rejected it. They said federal law preempts this, foreign policy preempts this, and they called it for what it is. They say you want the courts to legislate things you can't get through the legislature based on controversies that are beyond our capacity to even adjudicate.
But what I didn't like from what I read, and not from a factual political perspective, just from a legal one, is the court nonetheless gave credence, at least from what I could understand, prima facie.
Well, they technically had to because it's a motion to dismiss stage. So they couldn't contest the underlying factual allegations as to whether it really the climate apocalyptic theory was true. Okay. They had to presume, though I agree with you, their language was like, oh, yeah, we really are concerned about this too. And maybe they thought they needed to do so politically. Maybe they really believe it. Yeah, I know the guy's wife let him in, but that's not precisely how that whole thing went down. They had no right to go in there in the first place, period. And there's limits to consent to search other people's property. And that's not the grounds they're relying upon before the Supreme Court. They are not relying on consensual entry. They're relying on community caretaking. It's
an endless, it's not a slippery slope, people. And that's not a fallacy. That is a fact of life. And it's not a slippery slope. At some point, it's an utter free fall. And you see when it starts to happen, you're lucky, Robert. It looks like in the States, the courts are enforcing or at least setting it to the free fall. But, here we're seeing it, at least with respect to these health emergency measures. Courts are not getting involved, not anywhere near like they are in the States. But who knows? Maybe in time. So thrown out, are petitioning to SCOTUS, or it's not something that even if they did, they would accept a cert for?
On which case?
On the climate arguments.
Yeah, I'm sure they'll take it up to the Supreme Court, but U.S. Supreme Court's highly unlikely to reverse.
Okay, let's see what we got here. There was a time when I said I have absolutely zero chance of what happened to Rebel Media in the U.S. Sadly, not anymore. Yeah, I say the only problem with Rebel is that they knew that the police were there to instigate and to escalate, and Rebel may have very well done it intentionally. Because it is a great way to raise awareness. And at the end of the day, whether or not a little shove back is going to be the wrong thing, it's going to get the public outrage that people are just getting fed up with this, as seen by the guy getting tackled by 6 cops and struck on the head. And from what I suspect, because he wasn't wearing a mask.
Yeah.
Okay. Now, which one? Let me just get the chart here. Let's see what we move on to now. Let's quickly go over the Nike case, which settled.
Well, two predictions came true. One came true a couple of weeks ago. I said that the Toddy Westbrook case would be dismissed because the judge hated the lawyers and the litigants. In fact, happened the very next day. And Nike, you were right. That got settled quickly.
They settled it, so they're going to MSC.
They have to recall the shoes.
But they're not going to get the shoes back from the people who bought them, barring a court order enjoining anyone who purchased them. And I don't even know how they could possibly do that legally. People are going to hold on to those shoes, and they're going to be worth some serious coin. But I'm going to make another prediction. I swear to you, this smells even more like a publicity stunt, because everybody's a big winner in this. Even the courts, who now get to enforce justice in a sense. I swear to you, it looks like Nike and Mischief, or MSCHF, colluded to do this. Great marketing for both. And even MSCHF's lawyer, or I think it was the lawyer, said, well, we've succeeded. Our brand has gotten recognition. Now we've brought the highlight to the absurdity of these collabs. And they're not really going to lose any money, because I think it might have not been a not-for-profit, but it was, it was an artistic endeavor in the first place. All they've got to do now pretty much is reimburse and maybe give back the money to Nike. And hold on. So let's move on to another subject.
Also coming, I think it was out of New York, where Rappaport got slapped around by Barstool and Dave Portnoy. Or maybe it's Portnoy. I've never known how to pronounce his name. But there's actually a good deposition where Portnoy took apart the lawyer, because the lawyer made some basic factual assumptions wrong. I'm no fan of Michael Rappaport. For the backstory, Rappaport had a podcast with Barstool, was always going crazy. And I can say that because the court said that, as long as you put it in certain context, you can say pretty much anything about Rappaport. I'm not a fan of Rappaport because he said some things in the Covington context that he later took back, but I was ready to sue him if he didn't. But Rappaport is kind of a nut. But, I mean, what Barstool said about him, I mean, they said he had herpes. They said that, which was not true. They said that he stalked people. They said that, it was like a wife beater, girlfriend beater, no evidence of that either. Also said he was a racist. They had like a fraud. They had like every name you can call someone. And the judge's ruling was intriguing, because the judge's ruling was they called him so many names that nobody could believe they were trying to be factual.
It seems like a no-brainer. There's two things. I saw Rappaport having an utter meltdown. I don't know on what interview it was. It was an utter meltdown. And I genuinely, everybody knows this, I feel bad for people who don't feel bad for themselves. I felt bad for Rappaport. But I've been following Rappaport for a long, first of all, True Romance, might be our first movie.
Oh, great film.
Great movie.
Also that cop film, Copland. He was great in that too.
Great movie. But he's
just a little...
Well, no, he's an absolute a-hole in real life. At least his persona is.
His public persona is. He said some stuff about the Covington kids that was patently false. He was going to get himself sued into oblivion. But I did look at it and I thought, that guy's so nuts. I don't know if anybody would take him seriously. I don't think anybody could say, oh, what he's saying is factual. Turns out it all backfired on Rappaport, because they're like, they could see what this argument was like. And basically the judge was saying Rappaport's kind of a nut anyway. And Barstool was just going off on him. And they called him so many names that none of the names they called him could be considered factual.
Well, and I absolutely agree with it, because that it's just as much of a trolling jab as Rappaport himself doles out on social media. Rappaport's remorseless. And he
just got kind of smacked around by Portnoy and Barstool, and they're going to get to walk legally, at least on those claims. If
anybody hasn't seen it, it was the 7.5-minute highlight that Portnoy shared on Twitter. It's amazing, because I don't blame the lawyer. Everyone in the comment section saying what an incompetent lawyer. When you don't know the facts that you don't know, it's hard to know where it's going to go. The thing is not to be arrogant, cocky, and assume It's maybe
I think they assume things about Portnoy they should have known better on. So, Portnoy has, entered the GameStop space. He entered the other things. He's not only a great marketer, he's a very sharp guy. So you got to know who it is you're deposing. Don't assume, hey, he's a sports podcaster. It's called Barstool. He kind of does over-the-top personality. Don't assume he's like your own client Rappaport. He was a little sharper than that.
All right. This is another thing where, I'm talking about Nelson playing off what might be his weaknesses for his strengths. Rappaport also... You may not think he's the sharpest tool in the box, because he depicts himself as I don't know how to describe it, like the guy from Good Will Hunting. He puts himself out there as someone who's crass, crude, unintelligent. He's not. And so when he's sitting there answering the questions, because the question the lawyer was asking him is, did you deliberately set this whole thing up so that you could fire him and then defame him? Because
talking about Portnoy, right?
Yeah, Portnoy. And because you had all the shirts prepared before you fired him. And his answer, breaking down the timeline, was, I made a mistake and fired the wrong Michael, and had all the stuff ready already. So when we were going to fire him, we knew that he was going to go off and it was going to be all ready to hit the market, so to speak, the social media market. And the lawyer ended up eating it because the premise of his questioning was temporally and factually incorrect.
Yeah, Portnoy just took him apart, and he got to take apart Rappaport, and he got to dodge any facing a jury trial, at least on the defamation claim. So it was just a big win for Barstool all the way across the board.
What is left of that case?
Just some contract claims mainly.
Okay, which will have a limited price tag in any
Very
event.
limited, yes.
And Alyosha says Nike went through the motions to distance the brand. They accumulated free advertising prices, and not only that, everybody was saying, "What about the Jesus shoe?" And they got the Jesus shoe in the settlement as well. I don't know what was left of it, the 24 shoes, but they got it all, and it's great publicity for everyone around the house. Let's do the library one because it's very interesting, and this is where my brain shuts down. I understand the facts in this case, but there's some stuff I just don't understand. SEC filed a complaint and filed a lawsuit against Library, LBRY. We'll call it Library.
And Ripple.
And Ripple, which I know even less than Library, but the basis
of threatening Odyssey.
Okay. And so the basis of the lawsuit is that, from what I understand, Library raised funds by issuing LVC, which were library video credits or library something credits.
Like tokens, different forms of digital currency.
Digital currency, digital tokens, because this is where I'm having trouble understanding. They say we'll give you tokens, you buy them, $1 a token, whatever. You get to use them within Library to tip other creators, to promote stuff. I guess the one thing is, I don't understand how Library works, and for someone who doesn't, I understand the idea of tipping, but can you cash these credits, these tokens out for real money?
They're used as, it depends on what they're involved with, but what they are, mediums of exchange and stores of value. And the SEC is deciding to relabel them security contracts. And because if they're considered security contracts, they have to register, they have to do a report, they have to do all these things they haven't done, which subjects them to civil and criminal liability and being wiped out. And labeling anything, and the reason why the SEC is even able to do this is they went after certain digital currencies that were also selling their currencies as a form of security contract, by doing things like initial coin offerings, ICOs, and by using them solely to raise. Here's what a security contract is. In my view, a security contract should be limited to publicly traded stocks. I'd never liked the idea of allowing the SEC and their little state mini versions of the SEC regulate purely privately traded contracts for investment or otherwise. I thought that was a great overreach. The SEC should be only concerned with publicly traded stocks, not private partnership deals, basically. But that ship has sailed. U.S. Supreme Court basically said, anybody who publicly markets a contract for the purposes of profit participation, to raise money for the purposes of profit participation, is a security contract. But that should be limited to that. What they did is they went after some of these cryptocurrencies that were selling securities, and then once there was a change of administration, for the most part, decided to flip over, and they want to basically get rid of cryptocurrencies that they don't like by labeling them security contracts, which would just wipe them out overnight.
Was the token? I guess I failed to see how
the token is not a stock. You don't have any right to profit participation.
No right.
So in my view, right out of the gate, number two, it's not a contract. You don't sign a contract. You don't do it.
It doesn't entitle you.
It's not a security. It's not a security contract. Not governed by the SEC.
And no, obviously, no voting. No participation.
Right, none of that. I mean, this is a crazy. Their interpretation is, if you're doing anything to raise money, they even put this in the Ripple case. If you sell something, number one, two, that raises money for you, then three, it's a security contract. Well, that covers a ridiculous range of things. So the goal is simply to wipe out any digital currency they don't like. And while right now they've acknowledged Bitcoin is an exception, there's no guarantee they will constantly do that. Only the big role of institutional investors is backing them off from that. But it's a dangerous, perilous precedent. They're trying to preclude the ability of alternative mediums of exchange and alternative storage of value that, in their view, could use modern technology and blockchain in particular to undermine the monopoly that current state fiat currencies have in the world. That's how I see it. And legally, I don't think there's any grounds for it.
Well, I'm just brought up this super chat. We're going to get back to the context of Rappaport because you're right. I think we didn't get it. We may have taken for granted everyone knew already. Let's finish.
Oh, right.
Okay, but so hold on. So Securities and Exchange Commission comes in. They qualify the token as a security. My question is, how is it even a currency in the sense that how can you withdraw it for actual currency or Bitcoin or digital currency? Like how is the token digital currency if it's only good on the library website?
That's still a currency. I mean, you don't have to be able to transfer it for anything else for it to be a medium of exchange. It can be a medium of exchange within a controlled environment. That's fine. It's still acting as a medium of exchange. So the degree to which you can get it for particular currencies isn't what determines whether or not it's a medium of exchange. It's whether it functions as one. Its functional role. And historically, that's what the SEC even had recognized previously with Bitcoin. If something has the capacity to act as a medium of exchange, or at least that's its functional role primarily, and secondarily as a storage of value, then it's not a contract where you're saying, give me money for my business in exchange for you having a right to participate in profits. When it doesn't have the profit participation right, it doesn't have a contractual component, it shouldn't be a security contract under the law. But they're trying to make perilous precedent in these cases, and that's why they're so risky for people who care about the ability of digital currency to meaningfully function, particularly independent alternative ones other than Bitcoin.
And now let's follow through on the hypotheticals. The SEC says this is a security. You should have registered. You didn't register. First of all, what's the process going to be like? This is a standard lawsuit, I imagine. So there's going to be
an SEC civil action. Though theoretically, if they establish this precedent, they could bring criminal cases. So because they're unregistered securities under the SEC's view, and they didn't provide material information to everyone who bought it, so there could be refunds to everybody on the monetary value of it, which would just bankrupt everybody. So that would be the net effect. That they could they could later put people in prison on criminal charges if they went that route. So it's deeply problematic if digital currencies are now called or alternative coins, and the whole alternative coin world is suddenly called a security.
And now I don't want to give anybody any ideas, but obviously this would have the same impact on tokens on locals.
Yeah, that's why Odyssey is at risk.
Okay, and the precedent to support the argument is what in law?
None. What they're trying to do is use the ICO examples. Hey, these things were called digital currencies, but they were offering the future promise of tokens in exchange to raise funds, and the future token value was based upon profit participation, at least as my understanding.
Okay,
so that was you can't relabel something that's in fact a security, just put the label cryptocurrency on it, and magically it isn't a security. In the same way, you can't magically call every cryptocurrency or any alternative digital currency suddenly a security contract just because these other ones were disguising their securities as currencies. So they're using those precedents to extend it in a space that legally has never been done before.
This would apply to game virtual coins. Yeah, I mean, I guess so. That's the extension.
Oh, yes, it has frightening expansion.
How is Bitcoin any different? Which games that you can buy to coins, purchase them? Well, how is Bitcoin not a security?
The SEC has acknowledged Bitcoin as out of this loop for now. That's the only thing. Otherwise, they can always go back and revisit it. Politically, it's because of who's involved in Bitcoin. They're not going to go after a bunch of billionaires and institutional investors. That ain't happening. They're going after people that are big enough, but not so big to really be able to fight back to the same political scale Bitcoin backers could.
Amazing. And these are hefty fines and potential criminal infractions.
And it's basically a way to take out entirely the ability to operate a government unapproved alternative currency. That's kind of how it's really working, in my view, and storage of value that potentially threatens the monopoly that the state fiat currencies have on our mediums of exchange.
Okay, that's. Do I have any more questions on library? Does anyone have any questions on library before we backtrack just to give the context for the Michael Rappaport defamation and breach of contract lawsuit? Okay, let me just think of this for 1 second. So they're The next step in this, obviously, library is going to fight, but
Oh yeah, I mean the big one will be Ripple. Ripple will set the key precedents.
what is
Ripple? If Ripple wins, that will likely ripple out to library and Odyssey and everybody else.
And I'm trying to think of other platforms now that are using a similar type of.
Oh, there's tons once you really extend the logic, because again, they're saying, did you offer something to raise money for your company and then use it to fund your company? I mean, that's the definition of a security contract. I mean, I don't know if that has any functional limits.
But I mean, I'm thinking of merchandise now. I mean, it in theory, taken to an extreme or an absurdity, or rather just say the logical sequence, selling anything to support the business to the extent that it may appreciate in value, is appreciation of value is one of the criteria?
No, I mean, at least not the way they put out in that complaint. I mean, presumably they'll only apply this to alternative currencies, but logically, the SEC, it's a massive power grab by the SEC, which doesn't have any clear legal limits by their interpretation. I mean, it doesn't meet the traditional definition of a security. That doesn't meet the traditional definition of a contract. Definitely doesn't meet the traditional definition of a security contract. And they're saying they can still do it if it involves fundraising. Are you making profit? Are you fundraising? Are you selling something that we can somehow call a security, even though it doesn't seem to meet any traditional definitions or limits?
All right, well, that's very fascinating. Now I understand the exposure of this complaint and lawsuit. Potential
broad impact. Too few people are paying attention to it.
The bigger question is this also: the SEC as the entity. This is the administrative state. I mean, what the intentions here are obviously for government to centralize control over all currencies and to eliminate any.
The same SEC that became deeply concerned about broadly expanding what inside information meant to go after the GameStop folks on Wall Street Bets. That's who these folks are.
Can a company sell a gift card at a discount? They will make rules as needed. No, this sounds crazy. So
they'll lose. I think the courts will reject this because it's too broad, too far, even for the courts to adopt.
But what was the precedent that you had mentioned earlier that expanded the SEC's powers that the ship has sailed?
Oh, the ship has sailed, and then it doesn't have to be a publicly traded stock.
Okay.
Just promote it to the public, which basically is everything.
This feels like it has Nancy Pelosi. Okay, so let's go back. So back to Rappaport, just so everybody can appreciate it. My understanding is that Rappaport and Barstools did a podcast together. They had some business venture. Rappaport was fired. And after being fired was defamed. And then Rappaport sued for breach of contract and defamation. But it was the defamation side of it that was hilarious because Dave Portnoy and the entire team had printed up shirts with all sorts of insults because apparently they knew that when he got fired, he was going to flip his lid and go crazy online, which he did. And then they went out with this whole defamatory campaign to make fun of him like it was nobody's business, which they did. And Rappaport sued for breach of contract and defamation, and the defamation side of the claim was dismissed, and he's still got a breach of contract lawsuit for whatever their contract was between them.
Yeah, and I mean, other than the social media victory for Portnoy, the other big legal takeaway was that if you say everything crazy about somebody, it may be a legal immunity from defamation.
Well, that makes more sense because it becomes quite clear that it's just comical in its intent and not to be taken seriously. And
it was nice to see the courts recognize comedy and exaggeration for what it was. To not get caught up in the politics of it. And so that was a good indicator as well.
People are asking, Robert, Kyle Rittenhouse updates. Anything we can share?
No major updates. Linwood is not involved, and that's the scope of that for now.
Okay, now I read something else that Sidney Powell was representing Matt Gaetz. Have you heard?
I haven't heard that. The two lawyers that he appeared to hire are lawyers I know. I replaced one of them in a case, worked with one of them in another case. I wouldn't have hired them, but they're okay. I mean, it was weird as they're New York lawyers. So why you hire them for a Florida case? I'm not sure of. He'll be writing some big checks to him. I know that aspect.
Oh, no, Robert,
I'm not sure why they were hired, but I don't have anything negative against either one of them. It's just I found it an odd There's plenty of really good Florida lawyers he could have hired. So but hey, it's better. At least he hired somebody because that was better than where he was at.
No, and I know that,
yes, Jordan Peterson.
Oh, people, yeah. Oh God, that's funny. No, people often accuse you, Robert, of being like the father who thinks nobody's good enough for their daughter. But
I could give you a long list of lawyers in Florida that I've worked with. I'm just saying, if you have a case that's going to be locally governed in Florida, and the more of my suspicions I think have been confirmed because I suggested that guy that he was his associate was setting him up, and I still think that's the case. He cut a sweetheart plea deal, and the rumor is he's going to point a bunch of fingers at Gates, and I think he was setting him up from day one. And I think Gates had no idea. Let's assume hypothetically that Gates did have an affair with someone who turned out to be 17 across state lines. My guess, he had no clue that's the case, which means he's not guilty of any federal crime. But it wouldn't surprise me if this other guy set him up as potential blackmail extortion material in case he got into trouble, or his get out of jail free card, which apparently he's exercising, if he got caught. And so I'm still deeply suspicious of who's coming after Gates and whether he got set up. And I'm just saying, if you're in that position, general advice, if someone's an expert in that subject matter or they're really good in the court of public opinion, then you may hire them for that reason. Plenty of lawyers that fit that category. But otherwise, if you're going to be battling a political war, you're better off with, if you're going to go local, These lawyers are not national. They're New York lawyers he hired. I don't know them as national lawyers. Their expertise is New York. As far as I know, I mean, one of them politically, I'm sure, hates Gates. So, I mean, that's a peculiar decision by itself, or hates Gates' politics. So nothing against him. I'm just, I know it. The other one is politically aligned in Trump world, and that's why he keeps getting hired. But it's like he doesn't, to my knowledge, doesn't know Florida. I can name a dozen people that know Florida frontwards and backwards. Not me, other people. So it's not a matter. It's who you hire tends to show whether you understand what you're dealing with or not, and whether you understand the legal system or not, and if you're in a political war legally. And I'm just saying, these people aren't the best people to handle this. This is not a New York. If it was a New York fight, they make total sense. This is not a New York fight.
And I would say hating someone's politics in this day and age is tantamount to hating them. So it would be curious.
High risk. Has been good in the court of public opinion that I know of. So it's like, okay, that's what Gates needs. He needs to quit yipping, and he needs to have a good court of public opinion lawyer talking. And then that's on one side. And the other side, he needs people that know the Florida landscape and know how to, and people that, I mean, I'll give you an example, even though he does mostly tax cases. David Garvin's fantastic in Florida, in Miami. And you wonder why everybody respects him? Because he's whooped them over and over and over again. I've been co-counsel with him in several cases. That's just one example. Instead, he's hiring two people who, to my knowledge, have never practiced in Florida and aren't even licensed there. I mean, Dershowitz now lives in Florida. There's a good guy to hire. He could be good in both contexts. Court of public opinion behind the scenes. Whatever you think, and Epstein got a sweetheart deal first time when Dershowitz was involved with him. And that was in Florida that he got that deal. So whatever you think about Dershowitz, he's darn good at what he does. And so that I don't understand the logic. It seems to me like same small circle of Trump world that keeps referring their own little crew. And often those are poor decisions.
And I had to ask the question specifically because I brought up the comment. So if Sidney Powell's not involved, I don't want to get accused of having.
No, to my knowledge, she's not.
Okay. What we forgot to talk about last week, and I did my homework and made a video on it. And now, for the good or for the bad, I know what a lemon drop is and why it's not, why it's potentially not a polite thing to order under certain circumstances. Robert, I'm going to summarize my assessment of the case. This is the Don Lemon. I forgot the Heinz. Heinz versus Lemon. Allegation of sexual assault, sexual harassment, or I guess it's assault.
Intentional infliction. Yeah, assault, intentional infliction of emotional distress.
And for anybody who doesn't know, the 30,000-foot overview is Heinz is a bartender in, a part of New York. I'm going to forget now. Sag Harbor. But
it's the Hamptons.
So he's in the Hamptons. He's working at a bar. They shut the bar down. He goes out with his boss and other people. Sees Don Lemon at a bar. Apparently, all he wants to do is buy Don Lemon a lemon drop. Don Lemon says, "I'm just trying to have a good time." We skip over some facts, in my humble opinion. Then we get into Don Lemon coming out, seeing the plaintiff outside in the bar. The allegations are that Don Lemon puts his hands down his pants, rubs vigorously. and then stuffs his fingers in the guy's nose and says, what genitalia do you like? So, I mean, the story came out at the time. There's when you don't like someone politically and when you think that they're dishonest as media anchors, it's very easy to believe the stuff that makes them look very bad. Knowing the crowd here, knowing the crowd and knowing my own personal impressions, like once you're in the Cuomo world and the Cuomo brother world and you're in a world of lies and deceit, I'll be more amenable to believing the bad accusations, but these are all accusations nonetheless. I guess the first question is, why are we talking about it? And I want to know what you think of my assessment. Am I victim blaming by saying that reading that lawsuit, it seems to me that we skipped over some important details that are probably going to come out later, even if they didn't come out in the flat denial from Don Lemon?
Yeah, I can only have limited discussion about it because I now represent Heiss against Don Lemon. So appeared last week and haven't been able to get the file because the prior lawyers are refusing to turn it over. So I have to ask the court to compel it. Kind of crazy. You get some interesting lawyers in New York. I'll put it that way.
And I don't know if you can answer the question. Typically, when a lawyer doesn't turn over the file, it's because of unpaid invoices.
But in the States, you're not allowed to do that. Now, in New York, New York is weird. A lot of these places that you think are sophisticated have like old, archaic rules. Like their whole election system is archaic. So there's limited rights. For most folks out there, if your lawyer says I'm not, particularly here, if your lawyer says I'm going to quit on the case, and so new lawyers come in, but even if you fire your lawyer, they can't hijack your client file in most states. They have to turn it over. You can't use the unpaid fees argument or unpaid cost argument to keep. So you can't use, hey, I won't allow you to see the file or your new lawyer to see the file unless you paid me whatever money I demand get paid. Mm-hmm. Most states you can't do it. In New York, you sometimes can, depending on the circumstances. But that usually doesn't apply to like discovery or other items. Ultimately, they're going to give me the file. Or the court will order it, but one way or the other. So it's just an annoyance and an inconvenience. The second component is, I think plaintiffs' lawyers in general make a mistake that they tend to focus. Here's your typical plaintiff's lawyer, unfortunately. Somebody comes in, and the first thing that you're taught to do as a young plaintiff's lawyer is whether there's a deep pocket to sue. That's question number one. It's not. So question number one is there someone we could recover a bunch of money from? Question number two is, what damages do we have so we can get the most money? And then third is, what did they do wrong? What they did wrong always comes last, sadly, in a lot of plaintiffs' practices. So, I mean, this is why, the group that went after big tobacco, they didn't sit around and say, man, I'm really bothered by what's happening with tobacco and how they're lying to people. They're like, there's a huge deep pocket, number one. Number two, damages are going to be off the roof. Think about all the lives it lost, so on and so, medical expenses. And then they figured out the legal theory to sue them. So it sometimes shows up in complaint drafting. So I'm not saying it showed up here, but saying it's as a general rule that sometimes when you read a complaint and it's all about the damages and very little about the liability, it's because the plaintiff's lawyers don't know how to draft a case, or they draft the case the way they internally think, but doesn't sell well for court of public opinion or to the jury or to the judge. I have reason to believe that more facts are to be presented, and they're very helpful to the plaintiff and hurtful to Don Lemon. But I'll save that for now.
Okay, and I'm sorry, I want to get this out of here. What are the rules for amending proceedings in the United States? Like typically,
early on you can, but that ship has sailed, so you can't amend this. Like this complaint probably cannot be amended now. But in many court proceedings, you can amend it in conformity to proof at trial. Depends on the particular state, depends on the specific jurisdiction. So I think this case is still in the discovery stage. So we'll see. But I believe that there's more evidence that will come out that's very favorable to the plaintiff. And because the suit just didn't focus, if I had been drafting the suit, there would have been a lot more about the public policy impact of this case, the public impact of this case, and key facts that focused more on the liability stage than on the damages stage. And then people wouldn't have the reaction that you would. Like, this seems like something's missing. It is. And I think what's missing is heavily damning of Don Lemon. But that's to be
and we know what we've discussed in the past in terms of success leaves trails, and so does abuse. So
yes, it does.
And the question
for somebody to do a one-off.
Well, that's and especially just knowing the crowd. I mean, and knowing, I mean like the CNN crowd and the Cuomo, that's collusion in terms of concealing conspiracy. And I know what I think of Don Lemon, and I mean, I'm thinking back, and everyone was saying in the video, like there's video evidence of Don Lemon behaving quite inappropriately every New Year's Eve party that they used to have. So,
well, say a general rule, some people when they drink a lot behave very badly, and sometimes they get away with that for a while, and then sometimes they get caught.
The question that I had also was the flat denial by the defense. Is that's
a common thing in the States, though. In the States, you usually see just denial. And because this case was, there weren't a lot of, it was interesting with the press's lack of attention to this case.
Well,
in the Me Too era, why aren't people talking about some aspects of this case? People might wonder, there's been media bias in the matter.
There might be media bias. You don't expect CNN to report on it, but don't expect any of their sister or brother companies to report on it either. Because I worked in certain environments, or you've seen things in certain environments. What is accepted as normal behavior in certain environments would be shocking to others. Hence, why people get so disgusted by.
And what I do think is the case in general, not necessarily specific to this case, but I do believe male victims of sexual harassment and battery and other behaviors, we have not as a society done a good job coming to terms with that. And so often they are made to feel they experience things a little bit different than I think a lot of others do, because society doesn't welcome that behavior. It doesn't welcome the victims in the way they do in other contexts. And particularly if you work in certain industries, you may experience things you wouldn't experience in other places. And I think that's a problem. And I think it's a social problem that needs more exploration and public validation of that experience. We've done a pretty good job. Some say overreacted on women who've experienced sexual harassment. We've still undervalued how much sexual harassment of men happens. We've seen this in Hollywood, especially, and I think it's true of the media. If you get into Hollywood, there's a lot of harassment of men that takes place by other gay men, particularly. But it gets suppressed a lot more than should be the case.
And when, for example, guys like Terry Crews come out and talk about it, they get into
Brandon Fraser, another one. I mean, he left the industry for years because of the effect of what took place. I mean, it's just because it goes to male identity, social perceptions of what male identity is, that you shouldn't feel like you're a victim if you're a man as opposed to a woman. A lot of constructs that really just harassment is harassment, assault is assault.
Yep. And we got, I'm not going to read that one, but we stand on guard for She, which is a play on our Canadian anthem. And Cleopatra says, I've really missed being here lately, but I've been on vivabarneslocals.com. So I just wanted to say hi. Thank you for tonight. Have a great birthday and good night. Yeah, Robert, thank you very much for the birthday.
Yeah, vivabarneslaw.locals.com.
One more thing that was a quickie before before the questions?
Oh, critical race theory. That's what the Locals board voted as their favorite topic to make sure we covered. There's a new lawsuit new complaints with EOC and other people that's going to lead to a lawsuit in San Diego, identifying all the different rules that critical race theory violates. They have some interesting theories. They're pursuing a range of interesting theories, but the core of it is this is just race discrimination in violation of the U.S. Constitution, the California State Constitution, federal law, state law, local rules, because they go through and they detail all the insanity of what critical race theory involves. And it's just racial discrimination. It's treating people as less. They're doing it in training programs. They're doing it to school children. And this is just the latest fight back. And it's being led by Asian Americans because they are particularly offended and upset by this. Well, their kids are the primary target in part of it.
Absolutely. And I've had experiences of people who are of Asian descent saying, like, don't disclose that fact on written applications because you're going to get penalized. And it's everyone talks about the increase in anti-Asian hate crimes when you are literally penalized. I mean, there's a culture to be created here, but when you're literally penalizing Asian students, there's no other way to look at it. And it's a good it's a good group to file the lawsuit because it's not just angry white men anymore. It's any form of discrimination, any form of penalties to some group and presumptions of original sin to others. I don't see it quite as bad here, but it still exists here. But it is interesting to see the lawsuits brewing in the United
Count
States.
Dankula mentioned that it's becoming big in Scotland, and you're like, why? It makes even less sense there from a historian. Somehow the Scottish have been part of secret racial oppression around the world. So the insanity just keeps adding. Critical race theory and anti-racism is racist. They're teaching racism. They're instructing racism. They treat people differently based on race. It's illegal. It's unconstitutional. And more and more lawsuits are being filed every day all across the country to fight it.
From a procedural perspective, they're all going to be fought separately. Does it take one to get up to the Supreme Court to set the precedent? Like, how does this ultimately get resolved?
Well, really just winning at any level. The more that win, then you can put a cascade, a domino effect of others winning. So it's, I believe one will go to trial in Vegas here in late April. At least that was when it was originally scheduled. I'm one of the lawyers that's on standby to assist in some of these cases if they need it, because I find it deeply problematic. It's not popular, by the way, within the African American or Latino communities either. This is only popular in woke world.
Okay, I know one more, the McCloskeys, because it's a quick one for anybody who doesn't know. Cannot be summarized. Go watch the video I put out 3 or 4 videos ago. But Patricia McCloskey, Kim Gardner had appealed their dismissal in the Kim McCloskey.
The prosecutor's exclusion. The prosecutor had appealed whether the prosecutor could be excluded from the case, given she raised money on prosecuting them.
She raised money on prosecuting, which may have influenced some of the investigation's techniques in terms of making sure they have charges to press so that they can continue to raise money off of it. Kim Gardner's office, circuit attorney, and her entire office booted from the file. She appealed. The judge said no for the same reasons. They just denied the writ, but the decision kicking her off was
she's done an independent counsel that will handle the case. So the Missouri courts made the right decision there. And there was one other case on that will just be briefly mentioned. Another case, kind of like Don Lemon case, where there's not much public attention to it, though there's major public policy impacts potentially from the case, is because solely of the narrative, the Deshaun Watson matter in Texas. You have a prominent NFL quarterback, has more than 20 plus accusations against him. Apparently during the pandemic, he decided to use Instagram to reach out to masseuses, regardless of whether they were registered masseuses, and was using Instagram as his communication means. Admitted he engaged in relations with several of them, claims they were consensual. A bunch of others say it wasn't consensual the way he behaved. But the media, if his politics were different or the narrative was different, you'd be hearing all about it on ESPN and everywhere else. Instead, they're mostly burying it because they like him politically.
Robert, before you sent me the link, I had not heard about it at all. And, I read the summary of the complaint because it's not anything I'm going to do a standalone video on. It's just, who was the football owner who was caught on camera at the massage parlor, the big one?
Oh, yeah, the New England Patriots owner. Yeah, and look at how big, because he was seen as a Trump backer, massive news all over the place. Even though that, and that involved something illegal, but it wasn't alleged to be non-consensual. This is alleged to be a non-consensual behavior.
Robert Kraft.
I think there's more than 22 women. And my guess is most of these women are probably African-American women. So they're being ignored because Deshaun Watson has a favored status within woke sports world. And it just shows the hypocrisy that's taking place consistently in the media covering some of these matters.
Similar thing in Canada that happened with Jessica Yaniv, who was going to waxing parlors and demanding that women wax Yaniv's genitalia, and by and large targeting immigrant women, first generations, the most vulnerable in society. But you have intersectionality of issues here, where one is purported
the oppression Olympics.
Yeah, no, it's we can quote Gad Sad here, but yeah, it got some coverage just because at one point it got to be so excessive when people found out about it. But it actually had the courts not blessing, but it had the courts' assistance in keeping it quiet, because you had publication bans, you had the courts basically protecting a plaintiff who was systematically harassing very vulnerable women on very spurious legal bases, and it finally got. She ended up getting an unfavorable decision in the courts, but No, it did not. It did not. Did not have the loudspeaker it would have had, but for certain elements being somewhat different.
So for some of the locals questions from John Halgren, he asked about the rebel media arrest, which you addressed.
Oh, and one person had asked about the pastor kicking the police out. Look, we'll see what happens there. He succeeded that day. Artur Pavlovsky in Alberta, kicking them out, and enraged when he did it. We'll see what they come back. We'll see what fences they come back with this time, and at what point does public opinion start to sway from?
Yeah, how much does the public pushback change the equation, as it has before in Canada? From Fantastic Realist ask about the ability to restructure states. So if a county wants to become part of a different state, they have to get consent of that state, the new state, and Congress. So that has happened. West Virginia, for example, used to be part of Virginia. There's other states where that's true of, but you have to get the approval of your state, the new state you're joining, and Congress for that to function. From Wizened Sage, what do we think about this? The commission to look at SCOTUS. It's most likely to come back and say, man, we really need to add some Supreme Court justices. But caveat, the reality is we probably do. Just we shouldn't pack them so that one side or the other can make a decision. Because like last week, they had 75 petitions. They took one. So some would say that's laziness. But, I would never say that. My evil twin, Paul, might. But Dershowitz outed him weeks ago. But there is probably an argument that, we have the same number of justices as 100 years ago. And they're handling even fewer cases in some context. And that's becoming a bit of a problem. So there is an argument for, for a bigger Supreme Court, just not to pack the court in the way a lot of Democrats want. So, but I think that's what that commission is all about. And a bonus question from Amadeus. Was the $100 million to Joe Rogan pay off so that he wouldn't play a role in 2020 like he did in 2016? As it came out this week, there's even more videos being censored with Joe being silent about it. Well, you can draw your own conclusions.
And I'll bring this one up because it's a good way to end it. John Gillan says, I wasn't going to do this, but happy birthday, Barnes. Robert, what do you have planned for the evening? It's still early where you are?
Yeah, relatively. Nice weather out here in Vegas. So I'll be putting, as Pierre Salinger once explained, he came through I think it was Canada, might have been the U.S., where he had all of his Cuban cigars seized back in the 1960s. And he was complaining and he was begging. And then he was like, okay, he goes, well, what are you going to do with them? He goes, I bet you're going to destroy them one by one. And I may be destroying this one by one a little bit later on. And then again, the best birthday gift, give a gift to yourself, give a gift to your friend or your family through gift subscriptions at vivabarneslaw.locals.com. Join today and have some fun, because that's where I'll be in the live chat after party just a few minutes after we're done here.
And I have to do an Ask Me Anything response, which we're going to get to. I'm going to get to this week. I am not as prolific as Robert on our page, but I am getting better at putting out exclusive content there when I especially get frustrated, or at the very least when I go exploring. Kevin Kowalczyk says, opinion on AOC having called cops to home of someone on Twitter mocking her rhetoric as, I didn't hear about it, but I'm definitely going to look into that because, oh my goodness. Now,
we don't know if she was the source or not, but if she was the source, that's incredibly petty and deeply. It's just how politicized our Capitol Police and the FBI are right now.
All right. And with that said, Robert, do you want to bring us out of the weekend and lead us into a new week with something that might even encourage me, given what I'm seeing going on? I can't leave the house, by the way. 8 o'clock curfew. I have a dog, but 8 o'clock curfew.
Yeah. Oh yeah. You have a cute, adorable dog. Though my favorite videos to watch are when cats attack the veterinarian and the dogs attack those. I can't get enough of those. But yeah, I mean, it's my birthday, and it's what my Alex Jones once asked me. He goes, well, why are you always so cheery? And I'm like, well, not dead yet, not broke yet, all good, and still here, so all good.
Amazing, everyone. Enjoy what's left of the rest of the weekend. If you're in Quebec, I hope you have a dog. Because the man who stole Sunset is making the rules. But sunnier days tomorrow. So enjoy the weekend. Robert, stick around. We'll say our proper goodbye.